Hey, good afternoon, everybody. Today is April 16th, 2025, big news. And we welcome you to Garfunkel Wild PC's webinar titled Starting the Patient Journey, Essential Documentation for Treatment and Payment. Me, Stacy Gulick, Kathleen Brown, and Allison Schimel will present this program. The content of this course is acceptable for both newly admitted and experienced attorneys. Please be sure you continue to stay connected on Zoom until the program concludes at approximately 1 p.m. Participants will be eligible to receive 1 CLE credit in professional practice. For New York CLE attendance verification purposes, all course codes announced during this program must be recorded on the attorney affirmation and evaluation forms and emailed to Ivan Rodriguez. We will send you the paperwork after the presentation, but we've also included here in the chat box links to where you can get the paperwork if you want to do it yourself. Also, we wanted to note that you can send questions that pop to your head throughout the presentation. You will need to either type them in the chat or you can include them in the Q&A question and answer page. We will get started right now then. Please don't hesitate to ask questions. We will either address them as they come up at the end of each section or at the end of the presentation, depending how time's going and that type. So with that, we are going to start our presentation. We wanted to just talk a little bit about who needs to listen to this and what we will be discussing, because it's a pretty broad topic that could include a whole slew of other things. So we will be discussing the admitting documents that are needed for hospitals, clinics, outpatient facilities like ambulatory surgery centers, D&T centers, and physician offices, basically acute providers. We will be focusing on federal requirements as well as state laws in Connecticut, Florida, New Jersey, and New York. We will not be discussing admitting documentation for long-term care or hospice programs. Those documentation, the documentation for those types of entities is a bit different and longer, so we are not including that in this program. In addition, we will not be discussing unique documents that might be required for mental health or substance abuse treatment facilities. You are free to ask questions about mental health, substance abuse, that type of thing. It's just that the slides themselves will not contain that information, but we probably can answer questions about that. So with that in mind, and everybody who now is participating wants to participate, we will move forward. Okay, so we're just going to talk initially about the basic consent to treat. So you could say, do I need to get consent just to give routine treatment, nothing invasive to patients? There is no law or accreditation standard really that you could point to that says you must get a basic consent to treat. But there is archaic case law that says if you don't get some kind of consent or the patient argues that they receive treatment without consent, that it is actually battery. Now, we have not seen recent cases about this, and people talk about this topic in regard to informed consent as well. So it is not that there is a law that specifically says you must get a general consent, but we do recommend that you do so. And you're going to hear us say that a lot during this presentation. Most of the things we're talking about, which is many laws that give us guidance as to what needs to be in these types of forms, there's not actually a whole lot that is actually mandated. We'll point out both too as we go along. So with that in mind, this general consent to treat that we usually see on admitting documentations does not take the place of informed consent. A separate informed consent would still be needed for invasive procedures or procedures that involve anesthesia, high-risk procedures, and other procedures that are mandated by law. That is a separate discussion that must be held by the treating provider. And remember, informed consent, just because I can never, those of you who know me, let you forget, that informed consent is the discussion between the patient and the licensed practitioner performing the procedures that involves the explanation of the procedure, its benefits, risks, alternatives, that type of thing. So the general consent and informed consent are two separate topics. We today are talking about the general consent when you first come into the facility. So the general consent can be obtained by the registrar or anybody at the front desk. It even can be sent to the patient in advance. It doesn't require that informed consent discussion that we were talking about before. And the general consent, if you're going to write a general consent different than what we provide here, should be broad enough to cover anyone who might be providing services at the facility or the physician practice, and should be broad enough to include every type of treatment that doesn't address informed consent. So physical examinations, radiology studies, medication, laboratory procedures, that type of thing. So that covers basically the concept of general consent to treat and why we do it and why we recommend you do it. I doubt if there's going to be a ton of questions about this. I think you're all pretty familiar with this topic. So then we're going to go a little bit now into the financial obligations, or the language that you want to have in a form signed by the patient to acknowledge their obligation to pay you, which everybody cares about a lot. So in order to subsequently have to collect money from the patient, you want the patient to acknowledge their financial obligations, including their obligations to pay deductibles and copays. Just a basic statement that you are receiving services, you patient are receiving services, and you have an obligation to pay us for those services. Even if you have a third-party insurer, there may be additional amounts due to the extent permitted by law. So you also want to include language reminding patients that from a practical perspective, they should agree to keep insurance information up to date and acknowledge the financial obligation to do so. So if a patient doesn't tell you the correct insurance information, you want to tell them, hey, if you don't give us the right information and your claims are denied, you are now responsible for paying us directly, not your third-party payer. In addition, subject to state protections around medical debt, and we're going to have a big conversation about medical debt in a little bit, providers can send unpaid amounts to collection agencies, meaning you can say, hire a collection agency to collect money from patients who you're chasing down. Those collection agencies will charge fees, and in order to pass along the collection fees to the patient, it is best to inform the patient in advance for the potential for such fees. And the basis for this recommendation is the Fair Debt Collections Act. And the Fair Debt Collection Practices Act, that's a mouthful, the concept behind that and some of the other consumer protections we're going to talk about is just a general philosophy that people should know in advance what charges they might incur from receiving the services that you're providing to them. So we're going to see here. So if they potentially have a collection agency fee or even an attorney fee to collect the fees, they need to know that in advance, or they might have a reason to not pay those fees, is the best way to say it. So keep in mind, as much as you can tell patients in advance, any fees that they might incur as a result of working with you, the more likely you're going to be able to collect those fees. Somebody asks, I see, can I get access to a recording of this webinar? Yes, we will send out a link. We will send out a link of both the recording and the slides and an outline if you need CLE of everything discussed today. So that will be sent out, and also in the chat box is a link to some of those documents. Okay, so talking a little bit more about what should be in your general financial responsibility form. If you are the type of provider that requests consumer credit reports, in order to comply with the Fair Credit Reporting Act, the patient must consent in advance. So you need to have that language allowing you to seek a consumer credit report. Now, not all providers get that, I get it, but some certainly do. So if you want to, the language has to be in the financial responsibility form. Finally, in order to run, as I said, we want to tell patients in advance how much money they might have to pay. So you also want to tell them that if they pay you by check, and it is your practice to charge for return checks, which is usually just most state laws, just so you know, is about $20. If you want to charge patients that $20, you need to tell them that in advance. So again, this is more language that you want to see in your financial responsibility form to make sure that you can collect all these charges and fees that you're going to incur in either to work with this patient. assignment or authorization for payment. So in order for a provider to protect its right to receive payment directly from the insurance plan or other third-party payer, you need language authorizing the payment to go to the provider. Some people call it assignment. I've seen courts be a little weird with the assignment language, so I often say authorization to receive payment, but you could try assignment. It's not that risky. But you want to get the patient in writing to agree that the provider can receive the money, that the money doesn't want to go to the patient. It wants to go to the insurance plan. And the reason for that is you don't want to be chasing the patients. If the insurance plan gives the money to the patient, there's going to be a significant percentage of times that patient might not turn the money over to you. They might go out and, I don't know, buy jewelry or something. So you want to have the payments come to you. In order to do that, you need to have the appropriate language in your financial responsibility form. Medicare takes this whole concept one step further. So Medicare says that a patient needs to sign each and every claim that the provider sends to Medicare. So that's the basic Medicare rule. If you want to submit a claim to Medicare, the patient has to sign off on it. Now, we all, and all of you who may do this, know that that is extremely impractical. So Medicare says, okay, if you don't want to have the patient sign each and every claim, you can have their signature on file. So Medicare has specific language about what they want to see in that, what they call the signature on file or SOFA language. And it specifically has to authorize release of medical information necessary to process the claim and authorize payment of the benefits to go to the provider if the provider accepts assignment. So the SOFA language for Medicare is somewhat mandated. If you're going to be paid by Medicare directly to the provider, you have to have this SOFA language signed by the patient somewhere, and most people put it in their financial responsibility forms. Okay, just one thing for the hospitals or other types of facilities out there that might have off-campus provider-based entities. So this is another thing that's mandated, not just me advising you to do it. If you have off-campus Medicare provider-based sites, and you are going to charge essentially the facility fee, the copay for the facility fee, in addition to for the physician service, you must provide written notice to the Medicare beneficiary of the beneficiary's potential financial liability, or an estimate, essentially. There's a lot of words there, but it's essentially an estimate of what that financial liability will be. If the beneficiary is unconscious, which I don't know how often that happens at off-campus provider-based entities, but if they're unconscious or under duress or lack capacity, the notice has to be provided to the beneficiary's authorized representative. If the off-campus facility provides services that are governed by UNTALID, then you cannot give the notice until the emergency has been ruled out. So until the emergency condition has been stabilized. Once the emergency condition is stabilized, then once again, you have to give notice of the potential financial liability as a result of the fact that this is a provider-based entity, so there's additional fees that could be incurred. So with that, that is a very quick kind of down and dirty summary of the financial responsibility forms. And I believe I'm going to turn it over to Allison for a discussion of some of the consumer protections. And this stuff might be the really appealing part of it, that there's a lot going on here.
So we'll start off by getting into discussions about surprise bills. So the best way to think about this is, like Stacy said, these are consumer protection laws. They were designed to protect patients from bills they don't expect. The idea behind it is that a patient should have a meaningful opportunity to make a decision about who is providing their care, what their responsibility is going to be for receiving this care. So there are various federal and state laws that require certain information about fees to be disclosed to the patient in advance. And collectively, all of these together are usually referred to as no surprise bills. So to start, we've got the Federal No Surprises Act and individual state surprise bill laws. Now, the Federal No Surprises Act went into effect October 2022, and frequently people think that that is the be-all, end-all, that steps in and governs everything. No, most state laws address most issues. The NSA was just enacted to fill in gaps where state laws either cannot or do not protect patients from common surprise bills by out-of-network providers. Now, the No Surprises Act and state surprise bill laws don't only address nuance, like little tiny random scenarios like an out-of-network provider at an in-network facility, which I know many people who are somewhat familiar with the NSA think that that's what it is, and it is. But there are other disclosure requirements that are required if a patient may be self-pay. So let's say they're uninsured, or for whatever reason, they are deciding that they do not want to be using their insurance for this service. Oops. Okay, so the NSA has several distinct components. So to start, there are requirements that have to do with emergency and post-stabilization services. Now, right off the bat, because this is not something that you're going to be able to get something signed in advance for, and that's really what we're talking about here. If it's an emergency service and you're out of network, you are limited to billing the patient's in-network cost sharing amount. There is nothing that you need to be providing the patient in that situation. You just need to provide the emergency services. Beyond that, the NSA has a prohibition against balance billing an insured patient for services provided by an out-of-network provider at an in-network facility. And we see this a lot at hospitals or ambulatory surgery centers with providers that may be providing services there. The No Surprises Act also has protections for uninsured self-pay patients by requiring disclosures of the expected costs of care. And then the No Surprises Act provides two different dispute resolution methods. So there's one for the first situation for an insurer-provider dispute, and then there's another if there's a dispute between the patient and the provider after the patient may or may not have received a bill. So, notice and consent under the Federal No Surprises Act. Certain out-of-network providers may still be able to bill a patient for services provided at an in-network facility if there is a valid notice and consent form signed by the patient. CMS did the hard work. They created the form. The link for the form we included here in the slides. It's in the outline as well. We strongly recommend that you use CMS's form. Sometimes we've gotten questions from people asking us to help them craft their own form. We do not recommend that, primarily because there is a presumption, CMS has said, that if you use their form, there is a presumption that the provider has complied with the requirements of the Federal No Surprises Act. Now, this form must be provided to patients separately. You can't include it in a packet of forms. So let's say you create one PDF that has 8 pages on it that you give to a patient. You need to have this as a separate document, so 2 PDFs. You also need to have a provider representative available, either in person or by phone, to explain the documents and answer any questions the patient might have. There is also a requirement that this be provided at least 72 hours prior to the appointment. If the appointment is the same day, it has to be done 3 hours before the provision of services. I know sometimes from an operational point of view, that can be difficult or challenging. This is what the requirement is. Keep in mind, if you haven't provided the form, it doesn't mean that you can't get paid. It just means that you can't bill the patient. So you would still be able to bill the insurance company. They'll pay you. If you don't like what they've paid you, then there's an IDR process that you can go to that CMS has in place. Now, the NSA form, the notice and consent form, cannot be used in certain situations. Remember, when we started, we said that the patient has to have a meaningful opportunity to choose their services. So ancillary services are those that CMS has determined are ones that the patient really doesn't have a choice on. So any item or service related to emergency medicine, anesthesia, radiology, pathology, neonatology. If there's an assistant surgeon being used, intensivists, diagnostic services. Also, if there is no other participating provider who could furnish that item or service. So they really didn't have an option. Oh, this doctor's in network, this doctor's out of network, and you're choosing, I want the out of network doctor. That's a choice. If there is no alternative, then they cannot waive their protections under the Federal No Surprises Act.
So what you're saying, Allison, is that the anesthesiologist can only collect the in-network fee,
Correct.
even if they're an out-of-network.
Correct. So what
Right.
a lot of anesthesiologists will end up doing is they'll bill the insurance company, they'll receive whatever the insurance company determines is correct payment. And if they don't agree with that payment amount, they think it was too low, then CMS has this independent dispute resolution process, and you submit it to there. And right now, anecdotally, what we're hearing, providers are not upset with how that process is going. Some have been comfortable with how that's been resolved. That being said, it is always possible that the plans will figure out how to recalibrate their payments so that in the future, the determinations will go more in their favor than towards the provider. But that would be how that would work for an anesthesiologist, for example.
Or any of these ancillary
Or any
services.
of these ancillary services,
Okay,
correct.
We also have a question from the audience which says, we have a patient who has a high deductible. He does not want to pay his balance and told us we should speak with our attorney because he should not get billed under the No Surprise Act. He states we should have told him how much he would have to pay prior to being seen. Are we okay sending him his bill? We are in network.
Well, if you're in network, then no, because there are two pieces here.
What's no? We can't send the bill, or yes, we can send the bill?
No, you can send the bill. The No
Okay.
Surprises Act does not apply.
Okay.
Because keep in mind, it applies in three situations. We've got emergency services. This is not an emergency service based on the question. The second is if you are an in-network, if you are an out-of-network provider at an in-network facility, you are in network. The third situation would be, and we didn't get to this yet, would be if you have to provide a good faith estimate of the cost, and that would be if the patient is uninsured or self-pay. This does not seem to apply based on this question because you're in network. So there was no requirement for that.
So the patient's confused.
Yes, yes.
Okay.
And it's very easy to get confused because the No Surprises Act is so new and so nuanced. And also because CMS has been making, tweaking adjustments along the way. So it is easy to get confused. And a lot of times people will just blanket say, well, this applies, then this falls under the Federal No Surprises Act. And more often than not, it doesn't. Okay, so now here's what I was starting to.
Actually, before we go to this piece, I'm just curious because, you think about, all right, emergency services, that's outside of the No Surprises Act, but what happens when the emergency no longer exists?
Right. So emergency services, so to clarify also, emergency services, this applies whether you're in network or out of network. No matter what, you can't charge more than the in-network cost share that a patient would have been responsible for. What happens when the emergency is over? So this is post-stabilization. And if certain criteria are met, then the service can move out of that emergency category. So typically the main thing that you want to consider is if the attending physician determines that the patient is able to travel using non-medical transportation to an available in-network provider or facility within reasonable travel distance, considering the patient's condition. If the doctor makes that determination, then it would shift over into a post-stabilization category, and you may be able to then shift over into the other aspect of, do you need the notice and consent? Now, if the facility was out of network, so let's say I had an emergency, I presented at an out-of-network hospital, they've now stabilized me. Do they need to get the notice and consent? Well, no, because remember, No Surprises Act gets triggered when it's an in-network facility, not an out-of-network facility. But if it is an in-network facility and you're getting services from providers who are out of network at that hospital, then yes, the Federal No Surprises Act would be triggered. Then you would have to consider giving the notice and consent form. And like I said, keep in mind, if you don't get the form, it doesn't mean that you're not going to get paid for any of the services you provided. It just means you can't bill the patient.
Now, forgive the simple question, but the stabilization being that a patient is able to go to another in-network location, but they're not required to.
They're not required to. Remember, this always comes back to patient choice. The patient has to have a meaningful opportunity to choose who and where they are getting their services and what they may be financially responsible for. So if the patient is able to, if they are in a condition to receive the information about the notice and make a determination, then that is their determination. If obviously they're not in a mental capacity state to make that determination, then that wouldn't be a post-stabilization situation. Okay.
I'm just going to remind you where you were.
Yes, thank you.
You with questions.
Okay. I was trying. Okay, so good faith estimate. So this is where we come. So now we're moving away from the whole in-network facility, out-of-network provider situation. Put that to the back of your mind. Now we're moving over to, you've got a patient, they are either uninsured or they've decided that they are going to be self-pay. They don't want to use their insurance for whatever this item or service may be. Those patients have a right to a good faith estimate of the cost of care. Providers and facilities are required to post a notice on their websites and on sites informing patients that they are entitled to receive this good faith estimate. Providers and facilities must provide the good faith estimate either upon a patient's request or at the time of scheduling the healthcare services. Now, this is only required if the appointment is scheduled at least 3 days in advance. And this is something that CMS has tweaked quite a bit because originally they had different time frame requirements, and then they realized after feedback that operationally it was challenging. And so they have this 3-day limit here. Now, once again, CMS has created a template that includes all the information that you need. The link is right here on the slide. The disclosure, if you are going to make your own, again, best practice, we suggest using CMS at least as a frame of reference. You need to have the patient's name and date of birth on there, a list and description of the items and services, diagnosis and service codes, and what the expected charges for each of those items will be. Include the provider's name and PI and TIN, a list of any related services that may require separate scheduling. So you don't want to blindside a patient. If there might be some visit or other provider that they may want or need or prefer to go to after having this service, but that is not included in the estimate that you're giving them, you need to let them know. There's also a series of disclaimers that need to be included. For example, the GFE is not a contract. And there's very specific language. And that's why I say, take a look, even if you're making your own. I know sometimes practices like to have their own sort of formats. They like things to look uniform, so they want to make their own. That's fine. Take a look at the language that's on the CMS template because it's very specific language, and that's the language you should be using.
What if your estimate is wrong?
So if the estimate is wrong, you've got $400 wiggle room. And if it's wrong by more than $400, then there is a provider-patient dispute resolution mechanism that the patient can take the GFE, submit it to this dispute resolution mechanism, and then you go through that dispute process. So now moving over to state laws. And remember, we said at the beginning, typically state laws will govern, and if they really just steps in where state law doesn't necessarily address this. So unlike federal law, New York actually has additional disclosure requirements, including information that must be posted on provider and facility websites. And there are different disclosure requirements depending on the type of provider or facility, but you should check what you need to be putting there based on what kind of provider you are. Because if you don't provide these disclosures, it can trigger a subsequent bill as being considered a surprise bill. So for example, providers who are out of network with a patient's insurance has to inform those patients in advance that they can request the amount or an estimate of what they will be billed, similar to what we just discussed with the good faith estimate. They must provide this upon patient request, again, similar to what we just discussed. If an in-network provider refers to an out-of-network provider without explicit patient consent, that would be a surprise bill. And again, what we were talking about before, the provider is restricted to only collecting whatever the applicable cost sharing amount would be if they were in-network. New Jersey, also very similar. If the health plan professional does not participate in the health plan, then before scheduling a non-emergency procedure, the professional must inform the covered person that they are out of network and that the amount or estimated amount that the professional will bill the person for the services is available upon the request. If the patient requests it, you have to disclose that amount. And if a covered person receives an inadvertent out-of-network service, the provider is again prohibited from billing in excess of any in-network cost sharing amounts. And if they disagree on the fees that they received, meaning if the provider disagrees on the fees that they received from the health plan, then New Jersey actually provides that you would submit that to an arbitration proceeding. Connecticut's statute is a little bit more tailored in how they define a surprise bill. It's really limited to emergency services and non-emergency service rendered by out-of-network providers at in-network facilities, though it does also include layup services provided on the referral of an in-network provider. And again, insured patients are only required to pay the applicable in-network cost sharing amounts. Florida as well, also a bit more tailored, addresses emergency services, defines surprise bills to include non-emergency services rendered by out-of-network providers at in-network facilities where the patient does not have the ability and opportunity to choose a participating provider, and insured patients will only be required to pay the applicable in-network cost sharing amounts. Florida also, though, has cost disclosure requirements similar to what we discussed in New York, but it's really only for certain facilities like hospitals and ambulatory surgery centers. So before providing any non-emergency medical service, each of those facilities must provide in writing or by electronic means a good faith estimate of reasonably anticipated charges by the facility for the treatment of a patient's or prospective patient's specific condition.
So there's a couple of questions that have come through that I think just want to touch on.
So we're seeing a lot of questions about labs and stuff. We may address those after the fact.
Okay.
Most of the No Surprises Act deals with facilities, and they would not so much go towards labs. When the lab is an indirect provider, like there's an out-of-network lab providing services at a facility, you would then be prohibited under the No Surprises Act.
Right. So shifting over to medical debt, which Stacy had referenced earlier, there are federal and state protections for medical debt that do not extend to other types of debt, such as prohibitions against wage garnishment and property liens, prohibitions against reporting medical debt to credit bureaus, limitations on interest rates. Those protections don't apply, for example, to credit card debt. Now, as Stacy also mentioned before, providers can send bills to collection. However, several states have banned providers from reporting medical debt to credit rating agencies for use in consumer credit reports. Some states even add to that, saying that if you do, or if the collection agency reports it on your behalf, then that portion of the medical debt is void. You can't collect on it. This is something to keep in mind just separately when you're contracting with a collection agency to make sure that they don't include this information. Now, the key here is if you use a credit card to pay for medical services or items, it is no longer considered medical debt. You've now shifted it over to credit card debt. So none of these protections will continue to apply for those for that debt. And New York, thinking this through, back in October 2024, passed a new law specifically addressing credit card use. So to start, hospitals and healthcare providers are now prohibited from requiring credit card pre-authorization and from requiring a patient to keep a credit card on file prior to providing emergency or medically necessary services. DOH has clarified that You can ask patients to voluntarily choose to have a credit card on file. You just can't require it. And now this is the part that gets a little annoying. Every single time that a patient goes to use a credit card to pay for medical services or items, you need to, the provider must provide this notice telling the patient that they will be foregoing, that medical bills paid by the credit card will no longer be considered medical debt, that they will be foregoing federal and state protections around this medical debt, and the patient must affirmatively acknowledge foregoing these protections by paying with a credit card. We have gotten questions, does this mean every single time? Yes, it means every single time. You cannot have them authorize this in your first initial financial paperwork that you've provided them on the very first day that they ever came to you. It has to be every single time. What if they're paying online? What if they're paying by phone? You have to figure out operationally what's going to work in order for you to affirmatively get the patient to affirmatively acknowledge that you gave them this notice. Do you want to pop up on a website that has this come up every time you're going to use a credit card? If they're paying by phone, do you read it to them and then make a notation with the timestamp and what works for you? There's not a requirement explicitly saying that the patient has to sign saying that they've gotten this notice, but how else are you going to prove that they have affirmatively acknowledged that you gave them these protections?
We're getting a lot of questions about this, so feel free after the fact to reach out to us. This is definitely a hot topic in New York right now.
And I am going to pass this back over to Kathy now.
Right. So first of all, I just want to kind of put out a disclaimer here. As Stacy said at the outset, much of what I'm about to walk through are really going to end up being best practices more than anything else, as opposed to hard requirements for healthcare providers. That said, though, and part of this presentation, the purpose is getting it right from the start. And what is a best practice to have consents in place to be the most protective to a provider's ability to treat their patients and, in some cases, more importantly, be able to bill for that treatment. So first and foremost, I just want to put it out there, like, understandably, HIPAA is and should be the headliner when it comes to disclosing patient information. That said, there are numerous state and federal laws, supporting acts, if you will, that providers should be aware of. So first and foremost, just giving a very quick refresher on disclosing patient information. So as almost everybody knows, HIPAA allows for access, use, and disclosure of PHI for the TPO, the Treatment, Payment, and Healthcare Operations. These disclosures do not require specific patient consent. However, state laws may also impact whether or not those disclosures can happen without consent. So, for example, in New York, providers must obtain consent before disclosing patient information to a third party. This would include disclosures to insurance companies for payment. Now, although consent, it just says consent under the law. And consent can be verbal or it can be in writing, but it has also been interpreted that consent in New York can be implied. For example, if you have a patient that's presenting to the practice and hands over their insurance card, it can be presumed that the patient is consenting to sharing their information with their payers. That said, even though implied or verbal consent might be defensible, we strongly encourage as a best practice that you obtain a written consent, because that is always going to be the gold standard when defending any claims that disclosure was made against a patient's wishes. Now, in Florida, they have been much more explicit, saying that providers cannot disclose medical records to anyone other than the patient, their legal representative, or another healthcare provider that's involved in their care without getting explicit written authorization.
So Kat, just this moment there. So for example, under 42 CFR Part 2 in regard to substance use information, it says you can't disclose information to other non-substance abuse providers without consent. Would the consent language in the general admitting consent cover that, or would I need a separate?
No, the general consent does not cover these special circumstances. And for those things, another example being mental health information, it would need to be a specific authorization that the patient's aware that these disclosures are being made. So that would be an authorization more on a case by case or disclosure by disclosure basis.
Okay.
So now we're going to move on to a few things where I'm fairly certain healthcare providers may not necessarily have this at the forefront of their mind. So starting with the controlling the assault of non-solicited pornography and marketing, or CAN-SPAM. So the CAN-SPAM Act is a federal law that controls the sending of emails for commercial purposes, so advertising or marketing. Now, for example, a marketing or an advertising, you may think, well, what's a healthcare provider marketing or advertising email? Well, if a practice, for example, sends an email to its entire patient list to tout its new wellness program offerings, that's going to be an email that potentially triggers CAN-SPAM. So under the law of CAN-SPAM, you're not required to obtain a explicit consent to send these emails. Again, it's that implicit consent that if a patient is providing you with their email address, they are consenting to receive emails. However, CAN-SPAM does require that these advertising or commercial emails that are being sent out include language that allows a patient to opt out. Now, opting out can be something like just reply to this email or click this link to unsubscribe to no longer receive future marketing emails. But CAN-SPAM requires healthcare providers, it requires all commercial emails that, including those sent from healthcare providers, to include this opt-out. Additionally, if a patient chooses to opt out, then they have to affirmatively give their consent to receive those marketing emails again. So, and this will come into discussion later. If someone says, I don't want to receive these emails, you have to honor that choice and also fulfill it fairly quickly. So even though consent isn't required, again, as a best practice, we encourage that practices and providers do get that consent. Best to have it in writing, but not required if it's only documented in the record. And this is really just to avoid patient complaints and reminding patients to keep their information up to date. So now text messaging. The Telephone Consumer Protection Act, the TCPA, requires any entity to obtain an individual express written consent before sending text messages. However, there is some guidance from the FTC, or the FCC rather, the Federal Communications Commission, that says that for the most part, the TCPA's consent requirements don't apply to healthcare providers when they are sending healthcare related messages. Now, again, a non-healthcare related message like an automated text message asking for a general patient satisfaction or to participate in a general patient satisfaction survey, non-healthcare related text messages do fall under the TCPA and would require express written consent. Now, some who are familiar with the TCPA may be aware of an ongoing debate about its applicability to healthcare providers. We even have that debate in GW ourselves, but the debate really centers around how the law is written, and the Supreme Court, the US Supreme Court issued a recent decision saying that the TCPA, the language of the law, which was written in 1991, refers to devices that can auto-generate random numbers. And despite, technology evolving and despite all the changes to how text messages are sent, the Supreme Court has said that Congress has had plenty of opportunities to update the law. They haven't. So if you're not using this device, theoretically, the TCPA doesn't apply. That said, there's always an opportunity for law and regulation to catch up to today's technology, or at least come close to it. So when sending text messages, it's, again, a best practice to get the consent of your patients that they are okay with you sending them text messages. So one thing I do want to point out, though, is if, despite some uncertainties, if under CAN-SPAM or the TCPA, someone were to make a complaint and there was a ruling that the person sending either the email under CAN-SPAM or a text message under the TCPA violated either of those laws, there are potentially significant financial penalties. So under CAN-SPAM, each separate email that is sent in violation of the Act is subject to penalties up to over $53,000. So imagine sending, 1,000 emails. That penalty grows pretty quick. Now, under
I didn't hear me in the background exclaiming. I didn't appreciate the penalties. Wow.
Right. Now under the TCPA,
That's why we're so cautious about this.
exactly.
Yeah.
Exactly. So under the TCPA, though, the per text penalties are $500, but that can increase to $1,500 per text if the conduct is considered to be willful and knowing. So you know that it's violative of the TCPA and that you willingly do it anyway. Now, again, $500, $1,500 may not sound like a lot, but these type of automated messages, if you think about a hospital that's sending out a patient survey to all of its patients, $500 or $1,500 can rack up a bill pretty quick. So one last thing about random laws that we may not be thinking of is the FTC Act, which is, as many people know, is aimed at protecting consumers from unfair or deceptive trade practices. So how does this play in? Well, basically, and as the slide says here, it's important that you say what you mean and mean what you say, and oh yeah, do it too. So if you have a privacy policy that says you will not share your patient information unless it's explicitly authorized, but you do it anyway, that's a potential violation of the FTC Act. If, as I mentioned earlier, I apologize for that.
I apologize for that. Yeah.
So again, the misleading privacy policy, and then also, and as I mentioned earlier, if you provide someone with an opportunity to opt out of receiving emails or text messages, and the patient chooses to do that, but then that they actually aren't removed from your lists and they're still receiving emails, still receiving text messages, that could be under the FTC Act, a failure to follow up, and then you're not doing what you said you'd do. So that could be a violation of the FTC Act as well. So there's a few, odds and ends that we wanted to touch on. So a few final thoughts. So in particular, and we've had the question raised, well, what if I want to record my patient visits or my medical visits? Can I do that? Do I need to get consent? So for hospitals that are accredited with the Joint Commission, the Joint Commission requires that hospitals follow relevant laws and regulations regarding making and using those recordings, which include photographs, videos, your Zoom or Zoom or Microsoft Teams interactions that you might be having with your telehealth visits. If you're recording those, the Joint Commission requires that hospitals abide by local relevant laws. So under federal law, and in most states, it's not required to obtain express written consent to record medical visits. Now, for the states that we are particularly focused on, notable exceptions are Connecticut and Florida, where you do have to obtain all parties' consent when a conversation is going to be recorded. So you affirmatively have to get a patient's consent to record your telehealth visit, or even if you're in person. That doesn't need to be necessarily in writing. It can be documented in the patient record, but you have to note that you got the affirmative consent. Now, for the other states and under federal law, while you don't have to get express consent, again, it's a best practice. But this is to protect against any claims that there was an improper recording, but also just from a treatment perspective, it's fostering transparency and, it's developing trust in the patient-provider relationship. So again, we strongly encourage that consent be obtained in these situations.
Now, Kat, if we get consent to film because we need that to identify the patient, or we're going to use it for education, or it's part of treatment, does that allow us to disclose that information?
No, it does not. So again, these consents, you have to think about it, that you have to get the consent to take the picture, make the recording, create the thing. But then there's always the next step of getting the authorization of the patient to share it beyond the purpose of why you created it in the first place. So, when you're filming or taking a picture or recording a visit, you're doing that for your own purposes, but to share it beyond that, the patient needs to specifically authorize that.
Okay, so just 2 more additional topics, and then we're going to wrap up. Just a reminder that forever and always, and you guys should be super familiar with this, but HIPAA requires you to get an acknowledgement of notice of privacy practices. Remember, the first time someone comes to your facility or your practice, you have to make available to them the notice of privacy practices. Also, just a little pitch, don't forget to post it on your website and hang it up on the walls of the waiting room. So you have to get the patient to acknowledge that you fulfilled your HIPAA obligation. If they refuse to sign the acknowledgement, you can just make a notation in the record as to the reason for the, but a lot of people I've been seeing increasingly just add this little acknowledgement to their admitting forms rather than having a separate form. HIPAA doesn't care as long as you get the acknowledgement.
So is the acknowledgement a consent though?
No, the acknowledgement is not a consent, and people get really confused about this. Actually, there's a lot of confusion about the notice of privacy practices. First of all, it's not a consent to use the information as described. It just describes how the information is used. If consent is otherwise required, you still have to get the consent. Also, notice of privacy practices are not your HIPAA policy per se. You have to have the other HIPAA policies that you're supposed to have. The NOPP is patient-facing, and the patient is just acknowledging that you made available to them this notice.
Okay. Just one more quick question. What if the patient refuses to sign that notice?
Once again, you can just make a notation that you tried and call it a day.
Got it.
Yep. And a new topic that we've been seeing, and then people have been asking me to draft language to include in their admitting consents, is language about reproductive health. As you know, the OCR revised HIPAA last year in order to require you to get an attestation if certain people are requesting information about reproductive health, and the reproductive health was legal in your state. In addition, some states have added some additional protections, particularly New Jersey and Connecticut. In New Jersey, patients have to be informed that they have the right to withhold consent to release information about reproductive services. That notification about your right to withhold consent has to be given prior to the reproductive health care services being provided. And for that reason, a lot of people in New Jersey have been adding additional language to their admitting consent forms regarding this obligation. In Connecticut, similarly, the patient has the right that their information regarding reproductive health, and reproductive health is a very, very broad definition. If the patient has to consent to release of the reproductive health care services, and the patient has to be informed of the right to refuse consent. So in Connecticut, people handle it a little different. Some people are putting it in their notice of privacy practices, some people adding it to their admitting consent forms, but the patients do need to be informed of their right to refuse to consent to their reproductive health information being disclosed. So with that,
So I have the honor of giving the most exciting thing this entire presentation, which is today's CLE code. It is 04 E as in Edward, D as in David, T as in Thomas. That's 04 EDT.
so everyone, I really appreciate you joining. I know we threw a lot of laws and information at you. Please feel free to contact us if you think through all of this and realize, hey, practically, how am I implementing this? Do you have any model language, stuff like that? Please feel free to reach out to us. I know there's a couple questions here that we didn't answer. I have to admit partially because I need to clarify a little bit what was meant. But I will try to reach out to you guys because I think most of the people who are asking questions I know, to get back to you with answers to your questions once I clarify exactly what the meeting was. Really appreciate you joining us for this lunch hour, and have a great day.
And just for the person who just asked for confirmation of the code, yes, you got it right.
Thanks, everybody.